The quest to overturn the recent High Court decision declaring the BBI process unconstitutional formally kicked off at the Court of Appeal in Nairobi earlier today. Parties appealing against the damning High Court ruling poked holes in the lower court's decision, with lawyers representing Attorney General Kihara Kariuki accusing some High Court judges of launching personal attacks against the president. And as Sam Ogina reports, day one of the BBI hearing saw appellate parties putting their best foot forward with presentations from high-profile lawyers and politicians.
The commencement of the BBI hearing at the appeals court saw Attorney General Kihara Kariuki lay ground for the defense teams. The government's chief legal advisor was on the president's defense, claiming the head of state was on trial at the High Court.
But the learned judges were keen on very personalized attacks against the person of His Excellency the President. To them, the facts and the law did not matter. Neither did precedent nor the sovereign will of the people of the Republic of Kenya. The person of His Excellency the President just had to be found at fault.
In annulling the BBI referendum drive, the five-judge bench of the High Court described the process as a presidential initiative guised as a popular initiative. The Attorney General termed the assertion frivolous.
And you will notice, my lord, my ladies, that this regrettable claim resulted partly from the learned judges' reliance on Wikipedia. They resorted to Wikipedia as an authority. And for sure, Wikipedia cannot be a reliable authority for anything serious, my lords, my ladies.
Calling for the quashing of the High Court decision, the AG filed 31 grounds of contesting the High Court verdict against the BBI. The AG said there have been 22 unsuccessful attempts at amending the Constitution, and the President is not prohibited from initiating the process.
Every person in Kenya has political rights that are protected under the Constitution, and those rights include supporting or campaigning for any cause.
That nothing in the Constitution prevents His Excellency the President from originating an amendment proposal to the Constitution.
The President has the right to vote at every election and in a referendum. He has the right to vote. So the political rights in Article 38 cannot be curtailed unless by express words. And that the rights that are protected by Article 38 include the right to participate in the popular initiative route.
In the High Court decision, the President's involvement in the process seemingly negated the approach of amending the Constitution through a popular initiative. But lawyers for the appellant submitted that the referendum drive met the threshold of a popular initiative, the President's involvement notwithstanding.
If that article says the popular initiative is the work of the people and Parliament,
yes, does
that not mean that in the eyes of the Constitution, Parliament is not the people? We have the people,
yes,
and then we have Parliament.
Yes. The popular initiative route commences once 1 million signatures have been collected. Before that, everything that people will be saying, including the ideas that people would be having, that's not a popular initiative. That's an idea in the mind, or it's a suggestion that you have.
Am I a promoter? Certainly that word is so significant. And we should ask ourselves, why is the word promoter used? And why is there any prohibition in the Constitution? Who is stopped from being a promoter? It's like saying you judges should not vote.
The hearing continues Wednesday with the BBI Secretariat, the Electoral Agency IEBC, and the President submitting their defense. Sam Ogina, Citizen TV, Nairobi.